In this case study, our client is an absolutely terrific guy, hard-working family man who spent about 20 years building up the value of the childcare operation that he had developed with his co-partners. Unfortunately, the people that he built up the business with decided to freeze him out. And so he was put in a position where he was potentially excluded from all of the value that he developed over 20 years. What are the facts of the matter? Okay, client owned 1/3 of the shares. He was also a director. So that meant he was at risk of having a minority position. The other party, so the other directors, decided to engage a very aggressive counsel who went at his throat and developed all sorts of schemes to try and cut him out of the business itself. There was 20 companies and there was a lot of trust involved and there was a lot of real estate assets. So this was about a $20 million enterprise. It took a lot of time and a lot of effort and about a year of our litigation before a settlement was reached where there was an amicable separation of assets. How do we help Andrew? Okay, first step is we undertook due diligence to understand all the contracts and the relationships between the different entity in the corporate structure. There was about 20 companies. Then we represented the client in Supreme Court proceedings to push his case forward and object to the restructuring that had been undertaken by the other directors. Then we undertook direct negotiations with their lawyers and we worked towards a settlement which was fair but protected our client's interests. The good news from this case is that good guys can win in the end. Andrew was able to protect the 20 years of value that he had built up. On the other hand, this could have all been avoided if at the start of the relationship with his partners, he signed a shareholders agreement which gave him adequate protections for his minority position.